Good morning, everyone. Welcome to this Archor Webinar with special guest, James Frampton from Keating Chambers. We're going to talk this morning about the recent Court of Appeal case in RBH and James and the three interesting construction law angles that it throws up. So just very briefly, your two presenters today are myself and James, as mentioned. I'm Oli Worth, a partner at Archer. And James, I'll just let you introduce yourself.
Yeah, thank you, Oli. Good morning, everyone. I'm a junior barrister at Keating Chambers, and I acted, instructed by Oli, for RBH at first instance and then the Court of Appeal. And I'll now turn my camera off and let Oli do the first part of the talk.
So yeah, before we get into it, the detail of today's webinar is on the slide now. So I'm going to run through very briefly the case background just to put things in context a little bit. And then the three, as I say, interesting construction angles are the residential occupier exception, which I'll be covering. Then James will come back on to talk about the payless notice and a word on adjudicators' fees. And if we have time at the end, there will be a Q&A. Now, on the Q&A, you should be able to see on your screen a button which says Q&A, which should put through questions to me and James. If that's not working, just send me an email. social@archer.co.uk or my own email address, and we'll pick them up or pick them up after. Okay, so the background to the case. So the three main sort of parties or people involved in this, the contractor was RBH, Building Contractors Limited. The employers were private individuals, Ashley James and Tracy James. Ashley was and is a property developer, and Tracy works in the NHS, I believe. She's also the director of a company, as is Ashley. And they bought the property known as Ferndown in 2019 down in Devon, with the intention of demolishing it and constructing a new property. So RBH was employed a few years later in 2022 to carry out site and project management services. There was no formal contract agreed, at least in writing, but some terms were agreed, such as that RBH, and in particular its director, Mr. Huntley, would be paid a weekly or monthly fee. And as works progressed, it was also agreed that RBH would take on some procurement of subcontractors and suppliers and such like, and charge a fee on top of that. So the works proceeded up to around April 2024, during which time various invoices were raised by Mr. Huntley and were paid by the Jameses up to around £1.3 million. So around April 24, the relationship broke down for various reasons, and RBH left site, and another contractor came on and just finished the job off with the last few things. But the building was substantially complete and was put on the market by the James. And just to put things in a little bit of context, this is the property we are talking about. This is a screen grab from Rightmove, which shows it's still on the market if you've got £5.5 million to spare. But as you can see, it's a large luxury property in an area of outstanding natural beauty down on the Devon coast. So quite a fantastic property. So following RBH leaving site in around April 2024, in November 2024, an application for payment was put in by RBH, saying the total sum owing was 1.973 million, of which the 1.3 had already been received, leaving a balance due of £663,000. And as we'll come on to discuss later, in the first court hearing, the judge accepted that there was an Excel spreadsheet which provided a detailed breakdown to how that £1.9 million and the £1.3 million was arrived at, leaving there little doubt about how the balance of £663,000, the sum stated as due, was calculated. A few weeks later, in time, a purported payless notice was issued by Mr. and Mrs. James, which valued the sum due, or said the sum considered to be due on the date of the payless notice was nil. Now, James is going to talk about the payless notice in more detail. And if you go into the first instance judgment on Bailey, which is freely available, you can see the contents. I suspect this may be too small for anyone to seriously read, but in rough outline, it contained a heading, various bullet points, some of which had figures against them and some of which didn't, and said ultimately the sum due was nil. As I say, James is going to talk about that more when he comes on to talk about what the court said about it. But that was the document that was in play in the adjudication. So, as I say, there was an adjudication in December 2024 and January 2025, and that was commenced on the basis of a, as is colloquially known, a smash and grab. The fact that the application was issued, the Peleus notice was invalid, and therefore RBH's case was that the full £663,000 was due. Now, in response to this, the Jameses, who by this point had instructed lawyers, raised a jurisdictional challenge on the grounds that they were residential occupiers and therefore the adjudicator had no jurisdiction. And that's the first point I'm going to come on to discuss in a moment. The key point here is that the adjudicator disagreed with the jurisdictional challenge, disagreed with the Jameses' arguments that the Peleus notice was valid, and found in favour of RBH, saying that the Jameses had to pay £663,000 plus interest forthwith, plus pay all of the adjudicator's fees and expenses. Unsurprisingly, given their challenges, the Jameses didn't pay, and they also commenced Part 8 proceedings to determine whether or not the Peleus notice was valid. And that's a procedural technique whereby even if the decision had been found to be enforceable, a secondary question was whether the Peleus notice was actually valid and therefore whether the adjudicator was right. So in play before the court were these two questions. First, did the adjudicator have jurisdiction? And second, was the Peleus notice valid in any event? So the first issue to discuss is the residential occupier exception. Now we have to go backwards a little bit to work out why this is important. So as a reminder, there was no written contract in place, and therefore there was no adjudication provisions to refer to. And that meant that in order to have a right to adjudicate, RBH had to show that the right under the Construction Act section 108 applied. And that only applies to construction contracts. Now, you might remember Section 104 of the Construction Act sets out what is and what isn't a construction contract based on the nature of the works. And there was little doubt that the works here being undertaken by RBH were construction operations, and therefore there would have been a construction contract, other than Section 106. Now, Section 106 is the residential occupier exception, and the wording is on the screen. So that provides that the part, effectively the Construction Act, and the requirement to issue Peleus notices and the right to adjudicate doesn't apply to a construction contract with a residential occupier. And that is defined as a construction contract which principally relates to operations on a dwelling which one of the parties to the contract occupies or intends to occupy as his residence. Now, we'll come back to that later, but that is the background that we're talking about. We also need to just touch on summary judgment. Now, this is the mechanism by which most adjudication enforcement procedures take place. So it's the way that adjudication decisions can be enforced quickly, typically within 6 to 8 weeks of a claim being issued, rather than having to wait for the usual years long trial and full procedures to take place. It works because in most cases, the court is able to say pretty quickly that a challenge to an adjudication decision has no realistic prospect of success. And that's because over many years now, the court has consistently upheld, for policy reasons, adjudication decisions unless there is a clear breach of natural justice or the adjudicator lacks jurisdiction. And it's fair to say that in most cases, the court will find that there was no breach of natural justice or there was jurisdiction wherever possible. But the strict test under CPR Civil Procedure Rule 24.3 is that the court can give summary judgment, and that means effectively in this context, enforce the decision quickly, provided that the party defending has no real prospect of succeeding on the defence of the claim, or, and the second limb of this is, there's no other compelling reason why the case should go to trial. That's not relevant here. So the only question really is whether or not, in this case, the Jameses could show they had a realistic prospect of succeeding in defending or showing that they were residential occupiers. Now, the residential occupier exception has been in the Act since the start, but there have been very few cases, and there have been no reported cases where it was successfully applied. Now, the most recent, or the most useful, I should say, previously has been Westfields. Now, in this case, ultimately, the use of the exception was rejected, as I mentioned, but there was some useful commentary on how the test should be applied. So first, Westfield set out a little bit about why Section 106 was there in the first place. And as you can see from the quote on the slide, the idea was to protect ordinary householders not concerned with property or construction work and without the resources of even small contractors from what was in 1996 a new and untried system of dispute resolution. So effectively, the logic here was that you and I, who might be building a small extension or carrying out small construction works on their home, shouldn't be burdened with the idea that they might have to deal with an adjudication, the 28-day periods, a legal process and such like, and therefore it shouldn't apply to domestic householders. And you can see some logic in that, particularly given the way adjudication is now, with lawyers, experts and such like involved. Westfields also set out something on the test of what occupies means. So here it said occupies must carry with it some reflection of the future. It indicates that the employer occupies and will remain at or intends to return to the property. And it said that the position at the date of the contract was what was important. So effectively, Westfields was saying, in order to allow the exception to apply, you needed to show that you were either potentially in the house at the time the works were carrying on, if it was just an extension, or that you'd moved out and intended to come back to it as soon as the works were complete. And that was all important at the time of the contract. If things changed later, so be it, but it was the time of the contract that was important. And interestingly, it says at the end of this slide, in this quote in this slide, above all, Section 106 needs to be approached with common sense. It ought to be plain on a brief consideration of the facts whether the employer is or is not a residential occupier within the terms of the exception. So what the court was really saying here was it should be obvious if you're a residential occupier, because it just should be. And if not, then it probably doesn't apply. Now, interestingly, at the end of the Westfields judgment, the judge, Justice Coulson as he was then, made these interesting comments and said maybe it was time to give some thought as to whether Section 106 should continue to apply. Now, obviously, it does apply. It's in the Construction Act. Only Parliament can change that. But clearly, the suggestion here was that adjudication has worked well, and there's no reason in principle why it shouldn't now be extended to apply to residential occupiers as well. So, in this case, as I've said, the summary judgment test was whether or not the Jameses had a realistic prospect of establishing that they were residential occupiers and therefore the exception applied. So the court was required to weigh up the factors for and against. Now the evidence put forward by the Jameses pointed to various factors that they said showed that they were residential occupiers, or at least that they had a realistic prospect of establishing that at trial. On the slide are some of these. One of those is they paid additional stamp duty when they purchased the property, which you only need to do if you're intending to occupy it as a second property. They said it was their only house after they'd sold their earlier house in Essex, and they lived in a caravan in the garden during the build. They said they registered with the local GP and on the electoral register, all of which were consistent with the idea they were going to be moving in or intended to move in after the project was complete. They also said they fitted out the house to their personal specification, and there was a lot of discussion about a lap pool in the basement, which they said only they would do, and that was because they had a particular interest in keeping fit and becoming triathletes. They said that made no sense to put that kind of pool in a commercial development. They also pointed to evidence from friends, some WhatsApp messages and such like, which were consistent with the idea they wanted to live there permanently. Some evidence from their architect, which said he thought they were going to be living in the property themselves. And finally, they said, consistent with what they argued was their position, they intended to let out the property for around 12 or 13 weeks a year on an Airbnb basis, and that was going to be used to part fund the mortgage on the property. So the case against the exception, and this is RBH's case to say why the residential occupier shouldn't apply. First was that there were various companies involved. One of those called Trilogy, of which Mr. James, as a director, was accepted to be a property development company, and Mr. James accepted that he was a property developer. There are also various pieces of documentation from during the build phase which related to companies, such as a health and safety notice. And Mr. James's evidence was that he was told at the time of the contract, or just before it, that the James' intention was to let out the property on an Airbnb basis full time. He said that he was never told there was any intention to occupy the house as a dwelling for Mr. and Mrs. James. And in fact, that had he been told that, he would not have taken it on because his experiences were not in self-builds. There were also loan documentation, and this was RBH's main case, certainly in the Court of Appeal and also in the first instance hearing. And these documents came out as part of disclosure ahead of the first hearing. Now, these were development loans signed by Mr. and Mrs. James and guaranteed by Mr. James's brother, and also signed by one of the companies. And they contained undertakings, which I put on the slide, to the effect that there was no intention that the borrowers, that's Mr. and Mrs. James, would use the property. And the declaration that we declare, confirm and certify that neither ourselves or any of my family or close relatives reside nor have any intention to reside at the property. And that wording, have any intention to reside at the property, is of course similar to that which we see in section 106. Now, these declarations were made at the time the development loans were taken out, which was just before the contract with RBH was entered into, and again during the course of the project when the development loans were extended. They also contained the following undertakings, which not relating to intention to reside at the property, but made clear that the development loans and the purposes of those was intended to be for business purposes. And the agreements have been entered into for the purposes of a business, which RBH said was wholly inconsistent with the idea that these were effectively self-build loans, or it was a self-build project that Mr. and Mrs. James wanted to reside in. It wasn't a business purpose. So the court, at first instance in the TCC, was tasked with weighing up this evidence and deciding whether there was a realistic prospect of Mr. and Mrs. James showing they were residential occupiers, despite the evidence of the business loans in particular. And this is what the court said. I do accept that the loan documentation and the Trilogy documents, so those are the documents I mentioned which refer to Trilogy during the lifetime of the contract, in particular require explanation and very clearly raise the possibility that the house was being constructed as a development for onward sale, which was RBH's case, and in which case the residential occupier exception wouldn't apply. But the judge said that is part of the picture and had to be set against the James's evidence. And therefore, he said that the Jameses did have a realistic prospect of defending the claim, and the summary judgment application failed. So in theory, the case will have to go to full trial. RBH appealed on this point and on the payless notice point, which James will come on to discuss in a minute. And the Court of Appeal took the opportunity to, for the first time, comment on Section 106 and the residential occupier exception. Now, in doing so, it considered the case law, although it was unconstrained by that because that was all first instance and it was a higher court. But it made various points and principles which will now be binding on future courts. So whenever Section 106 comes up in the future, we will now have the RBH Court of Appeal judgment to refer to. And there were various ones. The first three on the slide here. The burden of proof must always be on the party seeking to trigger the statutory exception. So that, in this case, was the Jameses. So the burden is to show that they were a residential occupier rather than, for example, RBH to show that they weren't. It's a factual test which applies at the time that the contract was made, and that's based on what was said in Westfields. And the fact that it's an adjudication enforcement doesn't affect the summary judgment threshold. So while there is a general presumption that the court will look to enforce adjudication awards wherever it can, on a strict basis, that doesn't affect the test that we saw in the CPR. So if there is a realistic prospect of overcoming it, then summary judgment must be refused, even though it's an adjudication enforcement. The court went on to say there are two elements to the test. The first is whether there's a bona fide intention to occupy in the future, which is largely a matter of subjective intent. And in this case, the court would say the Jameses did have that bona fide intention, or at least there was a realistic prospect of them showing it, based on the evidence they put forward, the various witness statements, the friends, WhatsApps and such like that I mentioned. And second, that intention must be realistic rather than fanciful. So it's not enough for someone to say, well, I intend to live in this house, but having no sensible way of actually bringing that about. There must be an actual plan, a route which is realistic, such as an ability to attract financing or find the money to pay for the property. It's not enough that someone wants to live in a property, basically. And the intention to occupy, in order to trigger the exception, must have a temporal aspect. So that effectively means it can't be the case that someone might say, I might move in after 20 years of letting it out. There must be an intention to move in within a reasonable time, and that will always be fact sensitive. Now, applying all that to this case, in summary, the Court of Appeal said the judge was reasonable to conclude that there was a realistic prospect of the Jameses showing that the exception might be triggered, and therefore the summary judgment test had not been met, and it therefore declined to enforce the award. So that was the decision on the award itself, which meant that the decision that RBH had obtained in January was effectively unenforceable, and the question of the payless notice point effectively became irrelevant. But obviously, as it's an important point for the industry, the court did continue to look at it. So I'll bring James back onto the stage now, and he will run you through what the court had to say about that.
Yes, thank you, Oli. And in the same way that this was the first time the Court of Appeal was looking at the residential occupier exception, it was also the first time the Court of Appeal was grappling with payless notices other than S&T and Grove, where there it was limited to the question of incorporation by reference, and then of course the interesting point as to whether you had to pay up first. But in terms of the substantive requirements for a payless notice, this was the first time the Court of Appeal had grappled with it as well. So just to look at obviously the section 111, which will be well known to all of you, and the one point to pick up is this is the amended section 111, which is a point of relevance I'll come on to later. And effectively there are two requirements for what we all know as a payless notice. And 4A, you must specify the sum you consider to be due, and B, the basis on which that sum is calculated. The notice in this case, I think Oli had it on an earlier slide. Again, apologies if you can't read it very well on this slide, but there's a couple of key points to draw out. The first is it was actually headed Notice of Intention to Withhold Payment. And that was in fact seems to have been copied from the language of the original Act, as if drafted by reference to what the 1996 Act said, Section 111 said, rather than the Local Democracy Act amendments. The next point to pick up is it did say in the first paragraph, we intend to withhold payment of 663, which is the full sum applied for, and to make payment of £0. You then had the reasons for withholding. And again, that seems to be based on the unamended Act. There was then a list of 11 bullet points. I haven't put them all on the slide. I've put a selection of them on the slide. So 6 of these bullet points said, as for example, the first one, there was insufficient evidence to confirm what sum, if any, might be due, but did not say what sum they accepted. Now, 4 of those 6 did have a figure. So, for example, the first bullet point, we can see the figure of £94,000. However, that was the amount applied for Sheldon Southwest. So a figure from the application, not a figure which was being put forward by Mr. and Mrs. James. And those specific figures which were listed in the bullet points totaled only £295,000. 4 of the bullet points didn't refer to any figures, but if you, Mr. and Mrs. James' argument was, well, you go back to the application to figure out the value of these bullet points, and if you did that, the total was 1.245 million, so 1.2 million in issue, not £663,000. So that's kind of the document, the issue. And of course, it's been looked at 3 times. Firstly, the adjudicator. So the adjudicator said, well, if you go back to section 111, he found that 4A was met. The sum they considered to be due was 0. But the adjudicator found that 4B was not met because there was effectively a mismatch between the deduction 663 and then the calculation, because either the calculation is to 295 if you pick out the numbers on the notice, or if you go to the other bullet points. Firstly, on this slide, he said they set out no calculation figures, but then even if you do, you get to a higher figure. So the adjudicator decided that the pay less notice did not set out sufficiently the basis on which the sum due was calculated. We then come to the first instance judgment in the TCC before Neil Moody, KC, at that stage a deputy High Court judge, now a full-time High Court judge. He decided that the application was valid, and I've just set out his key reasoning on the slide, and it applies kind of common tests we're all aware of. It's how it would be understood by a reasonably objective reader. Does it set an adequate agenda for adjudication, kind of a test set in Henya and Beck? And the other point to pick out is he did not accept the letter had to have an arithmetical calculation. And that followed an earlier judgment a couple of months before in the case of JV and Finch, which I was also involved in, where in that case, in a different way, a payment application was held to be valid, set out a valid basis, even though it didn't have precise calculation to get to the sum applied for. It basically applied for a lump sum because it's still in words explained what works had been done. And if we go back to section 111, we can see that 4B asks for the basis on which a sum is calculated. It doesn't ask purely for a arithmetical calculation. So then the matter became before the Court of Appeal. So the TCC said, adjudicator said, invalid pay less notice. TCC said, valid pay less notice. Court of Appeal granted permission to appeal. Now, the first point to flag, which may be of interest, we may see a lot of going forward, is there is now a distillation of the relevant principles by Lord Justice Coulson for pay less notices, but also for payment applications, payment notices. Now, the principles he sets out, which I'll go through, are not, there's no real change to what was there before. On one view, it's very similar to the list which was set out by Mrs. Justice Joanna Smith in Advance in JV and ISCA, but it's a restatement of the list and a statement by the Court of Appeal, and perhaps also a change in emphasis, as I'll come on to. So just to run through the principles very quickly. Firstly, it's how a document will be understood by a reasonable recipient. So far, so good. That's understood. Second point, it must be construed in context. Now, the particular point which the Court of Appeal flagged here is that the context for a pay less notice will be the payment notice, or effectively the application, if it's an application which stands as a default payment notice. So that's going to be a key part of the context and was a key part of the Court of Appeal's reasoning. Thirdly, the court accepted that the payment notice or pay less notice must comply with the contractual requirements or the statutory requirements, which are the two we've looked at to set out the sum due and the basis on which it's calculated. But beyond that, it's a question of fact and degree, and repeated previous judicial comments that the court will be unimpressed by textual analysis or arguments which seek to condemn the notice on an artificial or contrived basis. Now, the fourth point goes back to the Logan construction and Sussex and Surrey NHS Trust case, that the Court of Appeal said there is no principled reason for adopting a different approach to different types of notices. In an earlier case, there'd been a suggestion that you would have a more stringent approach, perhaps, to a payment application than you may to a pay less notice. But the Court of Appeal did go on to say that the particularly adverse consequences if there's an invalid pay less notice were again part of the context. How would a reasonable recipient understand it? The fifth point, again, is it's well accepted in previous authorities. There's no requirement, unless it's expressed in the contract and as a condition precedent, perhaps, for a notice to have a particular title, refer to a particular clause, or a particular term. And it was on that basis the Court of Appeal ignored the reference to withholding, said, well, you may have used the language of withholding, but you didn't have to use the precise language of the current Section 111. And the final bullet point, the Court of Appeal repeated the test, which is often used. Does this set an adequate agenda for a true value adjudication? And gave the example that it may be insufficient for a notice to identify a figure and state without more that is the relevant amount. Although, of course, that would also not comply with Section 111B, in that wouldn't state the basis of the calculation. So those were the principles set out. In terms of, is there a change in emphasis, which is where I think there could be, the Court of Appeal summary is particularly helpful. And Lord Justice Coulston said the content of payment notices and pay less notices should be considered in a common sense way. They should not be allowed to become tick box exercises or traps for the unwary. And in reality, the question is a simple one. Wording which gives the title of this webinar, in fact, does the payment notice explain in a tolerably clear way what is due and why? Does the pay less notice explain in a tolerably clear way what part of the payment notice is due and why less is being paid? And it's tempting to regard anything else as loyally overcomplication. Now, it could be said that isn't quite what the statutory test has in mind, because the statutory test for a pay less notice is not anymore take the payment notice and what will you pay less. It's in fact for the payer to give their own calculation of the sum they consider to be due. But nevertheless, the guidance from the Court of Appeal here is very clear that the court was largely unimpressed by arguments seeking to say that notices which are served are invalid, and was going to adopt a lenient approach to the requirements for those notices. Albeit it uses the language of tolerably clear, the overall message is it's a lenient approach. So the decision, yes, the Court of Appeal agreed with the judge at first instance. This was a valid pay less notice. And just to pick up the 5 key reasons why. The first reason was that the Court of Appeal decided the payment application was unsatisfactory. Now, that may be regarded as slightly surprising when you consider the history that in the adjudication, there was a challenge to the validity of the payment application, but not in terms of its content, just the timing. That challenge was not carried forward at first instance. The Part 8 did not seek a decision that the payment application was invalid. The Part 8 was pay less notice only. So the James's effectively accepted that if the scheme applied, there was a valid application. And the judge at first instance referred to the Excel spreadsheet as providing a detailed breakdown. So it could be slightly surprising the Court of Appeal adopted quite a negative approach to the payment application, which wasn't reflected by the adjudicator, the judge at first instance, or even really submissions made by Mr. and Mrs. James. The second point the Court of Appeal relied on was that the letter said, and I've quoted the part of the judgment, expressly they intended to withhold payment of the entirety of the sum claimed. So it was clear effectively that nothing was going to be paid. And from there, the court, I think that shows that once there's something of that ilk making clear that nothing's going to be paid, from that starting point, the court is going to be reluctant to find what it may regard as technical arguments as to why the notice is invalid. Thirdly, the Court of Appeal held that the bullet points were sufficient because they were saying, well, you haven't demonstrated any of these sums are due, and that's enough. It's good enough to say in a pay less notice, well, you haven't established what sums are due. I think part of that must be seen in the context of this contract, which, as Oli explained, was a construction management contract. It wasn't for a fixed price or a fixed sum. It was effectively costs and maybe cost plus. So there's a debate about the plus, where you can see there is more scope to just simply say, well, you haven't proved those costs, whereas a fixed price that may be viewed less sympathetically. The fourth point was the Court of Appeal had a fair degree of sympathy for Mr. and Mrs. James as the amount of work which it said was required in a short timetable. Although, as I'll come on to, of course, that is a timetable set by the statute and the scheme. And finally, the Court of Appeal said, applying the final test, well, this does provide an adequate agenda for adjudication. So in terms of what lessons can we draw from this case, I think the first one, and they probably go together, the first one is, as I've suggested, I think this is the court adopting and in many ways confirming a more lenient approach to notices, and particularly I would say perhaps pay less notices, where the court is worried that a more strict approach will lead to a notified sum being due. And this is, I don't think this is the Court of Appeal acting out of step with the first instance courts. In fact, this has been a trend, I think, of the first instance court decisions in 2025. Starting place first in Carr, His Honour Judge Stephen Davis said at the end of his judgment that where there was a document which said, we're not going to pay you anything, he was relieved to be able to find that it was a valid payment notice or pay less notice. Secondly, the JV and Fincham case I've mentioned, where the court adopted a common sense approach to finding that an invoice, well, a document which was an invoice and just said the sum due is £48,000 and referred to areas of work done, was sufficient to state the basis on which the sum due is calculated, because the descriptions of work could be read back to an agreed scope and a plan which had some pricing, and that was good enough for that contract. So I think there is a clear signal from the courts that where a pay less notice has been issued, then generally they should not be condemned on what may be regarded as artificial grounds, as long as they have a figure which is due and some attempt at stating the basic calculation, that should be good enough. And perhaps there is a difference in approach between adjudicators who perhaps see a lot more of these notices and perhaps have a view of a stronger view, well, it's not that difficult, you should be able to get it right, and the court, which perhaps sees less of them and perhaps has a more of a view on the impact. And the other element of that is perhaps a wider commentary against smash and grab, and I've picked out one particularly kind of eye-catching part of the judgment, where Lord Justice Coulson referred to the unreasonably short period to consider and respond to a final account claim, but then of course went on to say, but that was in accordance with the scheme. So the Court of Appeal effectively saying the timetable in the scheme for a pay less notice is unreasonable, which is an interesting situation to be in, although effectively that then fed into the Court of Appeal's view as to what was good enough for a pay less notice, because they said, well, you have to think about what's good enough in terms of what's reasonable to expect in the time available. And in fact, I think it doesn't really appear in the judgment, but in argument, the court went further. For example, Lord Justice Coulson said, in terms, Parliament didn't intend for there to be smash and grab. Now, as we all know, that is how the wording of the statute has been interpreted, and interpreted in quite a strict way at the moment, in terms of pay the smash and grab first before you start the true value. But perhaps there is a sign in another setting that at least Lord Justice Coulson thinks there's too much notified sum claims, and that may also explain his reasoning and his decision here. And there's just a final paragraph of the judgment which summarises, I think, those two lessons. It's where Lord Justice Coulson said it's very important that payment notices and pay less notices do not become some sort of technical battleground where one other party seeks a potentially unfair advantage by relying on the short time periods applicable to them to recover sums. And of course, what you might say, well, that is entirely what the notified sum regime sets up. I think the message maybe this isn't the death or the end of smash and grab or notified sum claims, but it perhaps is a signal that your smash and grab and your notified sum may still work where nothing is served in response or something which clearly cannot get over the line. But if there is something which is sufficiently arguable that you could have an adjudicator go one way, a High Court judge go another, the Court of Appeal think there is prospects of success for appeal, but then go agree with the judge. If there is that sort of doubt, then it probably is not going to be good enough, at least in the court's view, good enough challenge to a notice if a notice is served and in time. So that's where we get to on the pay less notice. There's a third interesting point which was raised in this case was adjudicators' fees. Now this didn't end up in the Court of Appeal, but I think it's interesting, and for that reason I think it's helpful to discuss it, and not just because it's the one point I won on. The point was raised at first instance to say, well, if there had been a situation where RBH had won on the summary judgment, so the decision was in force, but Mr. and Mrs. James won on the Part 8, so there was a valid pay less notice. Now that would obviously mean, in terms of the enforcement of the decision to secure the sums due in the application, that would fail because it had been finally determined by the Part 8. However, there was also the claim by RBH for the adjudicator's fees, because the adjudicator had decided that Mr. and Mrs. James should pay his fees. So the question is, if the decision is reached in jurisdiction but found to be wrong on a Part 8 or Part 7, does the decision on fees fall away, or effectively could the fees be reclaimed? Now, historically, the view had been clear, no, that an adjudicator's decision on his or her fees was final. Now, the main reasoning, or the strongest case, this was a Scottish case called Castle Inns, and there were 4 reasons why the court said that. Firstly, that there was no contractual mechanism in clause 41A. That was the dispute resolution clause, effectively similar to the statute right to adjudicate, that allows such reconsideration to take place. Secondly, the right to have a final determination of the dispute, the Scottish court said, well, that's the underlying dispute. That doesn't apply to what it referred to as ancillary findings, such as finding on liability for the adjudicator's fees and expenses. And thirdly, which went with that, the decision on fees was ancillary, and there was no commercial need for it to be reconsidered. And there the court was thinking about, well, is there an implied term? What's the juridical basis on which we would order repayment? And the 4th reason was the difficulty of the court having to reconsider the decision on fees. And that maybe in some cases it's not very difficult, but you can see in principle where there could be issues, so I'll come on to. Now, as I say, that was a Scottish case in 2005. There were a couple of other English cases which supported that view, but the reasoning was relatively brief as to why that was the case. The Castle Inns case was referred to. Perhaps its best support was being referred to in Lord Justice Coulson's textbook, cited with approval. But the possibility for a change of view came through 2 cases. Firstly, Aspect and Higgins, where the Supreme Court, in deciding the ability to recover an overpayment, said there is an implied term that you can recover any overpayment to which the adjudicator's decision can be shown to have led. And the argument was, well, any overpayment could include, well, we only paid the fees because the adjudicator decided our pay less notice was invalid. Otherwise, we wouldn't have lost the adjudication. He wouldn't have ordered to pay our fees. So any overpayment is wide enough to cover that. Of course, the Aspect and Higgins did say that any overpayment could include interest, and there are other court cases which have talked about interest as being ancillary relief. So when we go back to Castleton's wording, the right to overpayment, the right to recover, doesn't include ancillary findings, you could put Aspect and Higgins together with those interest cases, I think it's Mullally and Leander, and say, well, ancillary relief was allowed there for interest. Why is the adjudicator's fees different? And another case I was involved in, the long-running saga of AV and Building Solution and JB Hopkins, one of those judgments dealt with the question of, could in fact, after the Part 7 trial, when AMV was successful, could they recover or effectively not have to pay the adjudicator's fees for the adjudication in which JB Hopkins was successful? Now, the other side weren't represented, but there was several rounds of legal submissions in front of Roger Tahar KC, although ultimately he decided not to address this point, which only emerged post-trial, post-judgment, because he accepted my submission that it wasn't, in fact, pleaded. But he did say there may be arguments to suggest that Castleton's should be reconsidered. So perhaps unsurprisingly, Mr. and Mrs. James picked up that wording, and they sought effectively to reconsider Castleton's at first instance. Now, just a couple of paragraphs of the scheme which I think are relevant here, which didn't really arise in AMV Hopkins at the time at which the arguments were taken, but were key in RBH and James, was how the scheme deals with fees. Because if you go through the scheme, you have paragraph 23 sets out the adjudicator can make the decision, and then 25 separately refers to fees separate from the decision. It also refers to determination of the fees, not decision. And the other key paragraph was 9.4 and 11.1, which is in the same terms to 9.4, which is that where an adjudicator resigns, he or she can still determine who pays fees, and the parties have to abide by that. Now, there's no ability for that to be reversed or changed, because the adjudicator hasn't made a decision. He's resigned, and 11.1 is similar. He's resigned. So if an adjudicator can make effectively a final and binding determination on fees where he or she resigns, why should it be capable of being opened up when he or she makes a decision? So Neil Moody Casey, who did have full argument on the point, he said he was not persuaded that he had the power to alter the adjudicator's decision in relation to his fees. And there were three key reasons why. Firstly, he said the prior authorities were all one way, other than AMV and JBH, but the judge just said that may be reasons to reconsider. So all the Scottish cases and the English cases had all gone one way, and Lord Justice Coulson's book, and he wasn't convinced they were obviously wrong. Secondly, he focused on the difficulty of review. Say you have a split issue case and the court's finding is the adjudicator was wrong on one issue but not on another. How does the court then decide what decision would have been made on fees? Also, there's a difference between saying on the full and final arguments before the court, the adjudicator's answer was wrong, to saying actually the adjudicator's answer on the arguments put before him and her were wrong. So how does the court grapple with that? So the difficulty of review, and also the adjudicators may not allocate fees purely on the basis of who was successful. They may also have regard to conduct or jurisdictional issues, serving too many documents. There's various other elements which can go into an adjudicator's decision on fees. Again, how does the court grapple with that? And thirdly, the judge looked at, okay, what would be the legal basis on which I could order repayment of the fees effectively, or set aside the decision on fees. And the main argument put was an implied term on Aspect and Higgins, which we just looked at, and the judge said no. That entitlement to fees is ancillary. Decision may depend on a number of facts. So that it's an ancillary relief, so it doesn't fall within Aspect and Higgins. But also, in terms of the Aspect and Higgins implied term, there's a causation test. any overpayment it may have shown to have led to. So for the same reasons as there may be very many different reasons why an adjudicator decides his or her fees, practical problems of review, it also poses a practical problem for that causation test. Can you say for certain, in all cases, it may be in this case you could have, but in all cases, can you say for certain that if the adjudicator accepted one legal argument, he or she would have had a different decision on fees? So that was the answer in first instance, and I say it wasn't actually appealed to the Court of Appeals. They didn't grapple with it. But I think where we are is now still the authority all goes one way, and there has been very recent authority to have reconsidered the issue, and specifically dealing with the potential argument which may be made based on Aspect and Higgins. So I think the matter is now settled, that subject to challenge to jurisdiction as between the parties, the adjudicator's decision on his or her fees will be final.
Thanks very much, James. Okay, we've got a couple of minutes before we finish. Two questions in, the first of which I can deal with nice and easily, which is, are the slides going to be available? And the answer to that is yes. They will be on the website later this week, along with the recording of this webinar. And obviously, if you've got any questions which arise afterwards or on a review of the webinar, then just drop us an email. The second one sort of covered a little bit, James. You said, well, the question is this the death of the smash and grab? And I think your closing remarks were probably not, but it certainly makes it harder if something has been served.
Yes, I think that's it. I think if nothing's served, then this judgment doesn't change anything. I think if something has been served, and I guess just to check what's been served. I mean, you often see, don't you, parties scrabbling around to find anything which they can say is a pay less notice. So an email where it's kind of clearly not got that intent. But I think if there is something which has been sent, which on its face if it looks like a pay less notice, it probably is a pay less notice, subject to, although the judge said it's not a tick boxing exercise, in one view they are reducing it to the tick box of, are there any condition precedents in the contract? Has it been served in time on the right people? And then does it at least state the sum due, which I think you can't really get away from. Although if you say nothing's due, that's going to be good enough. And then is there some elements of the basic calculation? But I think really it is very much limiting the challenges which could be made on the basis of calculation argument. So focusing on saying that is where it changes the emphasis to say that people trying to challenge basic calculation on what could be slightly technical grounds, that is where I think the court is saying, no, we adopt a broader common sense approach, and we're not really interested in those sorts of challenges. As long as there's something served which makes clear you're not going to be paid and gives you a bit of a steer why, that should be good enough.
Yeah, and that question of whether it's an adequate agenda for adjudication is quite important, isn't it? Because I think the court was presumably minded to think that, well, it was pretty clear they just didn't want to pay anything. So you go down that list of bullet points, and that would be the agenda for adjudication, and by which we mean sort of a true value adjudication. One other question just come in. The judgment is based on the application being less than ideal, and the invoices had not been provided to the James. If RBH had issued all the invoices, would it have changed the judgment? No,
I don't think so. I think it's pretty clear. Although it's the first reason the judge went to, the Lord Justice Coulson went to, I think it's pretty clear that overall the Court of Appeal's view was that the pay less notice was sufficient. And obviously they didn't find that the application was invalid, and they couldn't. That was actually already settled. They would have found they had criticisms of the application, and as I said, they may not be justified given the prior history, but the Court of Appeal's view on the pay less notice would have been the same regardless. And really it focused on saying, well, there's a claim for payment, and I think it was right that this is the first time a claim for payment and the figure of 600,000 was presented. That was really the Court of Appeal's key point. For the first time you get a claim for payment for 600,000, you've got 2 weeks to review it, and the reasons they gave were good enough. I mean, I think Lady Justice King made the point, what in the argument, kind of what more could someone do in 2 weeks? You're reviewing the line items. Do they really need to do more than just say, "Oh no, we don't think you've demonstrated that you've incurred this cost." So no, it wouldn't have made any difference as to whether or not there had been a prior record of all the kind of underlying invoices being given. And that, I think the judgment says, I think the judgment went slightly beyond what was discussed in the argument. The argument was there was a debate between the parties, as there was in the adjudication, have these invoices been given or not? We said yes, they have, at least most of them. They say no. But so that the Court of Appeal knew that was an area of argument. It wasn't really determinative. The key was they were looking at, okay, does this pay less notice do enough when you have 2 weeks to respond to a claim for 660,000? And they said yes, it did.
Okey-doke. And then one final one from me, really, which is I've obviously spoken about the residential occupier exception, and while it is a case decided on its facts, I just wondered if you had any comments on how the Court of Appeal approached that questions and the principles that it set out.
Yeah, I mean, I think it's I can see the principles. I can see why they set out the principles they did. I think the slight kind of nervousness you can have is, well, there's two. There's one is when you sign those loans, why should you be allowed to go behind the terms of the undertakings? And again, a point not reflected in the judgment, but their closing legal argument was, well, that we sign those undertakings as legal fictions. And I can see why the Court of Appeal perhaps didn't want to bring that to the fore. But if you're kind of signing something as a legal fiction, then why shouldn't you be tied to the legal fiction? I mean, the other point I think, which is worth bearing in mind, if you go back to the older cases, it kind of should be common sense, tolerably clear. I think if you have to go to the extent of the volume of evidence that Mr. and Mrs. James had to go to try and say, no, this was our house, it does really kind of strike you as, well, is that right? I mean, if you have to do that much work, that much evidence, shouldn't it just be really obvious? If one of us is having some ability to work to a house, there shouldn't really be any scope for any debate as to whether or not we're a residential occupier or not. And I think that's what, if you go back to what Parliament intended, that's probably only really in those very clear-cut cases they intended it to be. They didn't expect to have, you wouldn't expect to have such a big debate and so much evidence on it. So that's the only other thing I would kind of flag. But I can see the sense of the principles they set out. It just, who knows, it may give more scope for people to try and run the point again. And just, if you can get enough weighted evidence, you can say it has to go to trial. And the reality is people will be very reluctant to go through the time and cost of trial to actually kind of prove these points.
Indeed. Well, perhaps at some point Parliament may take up Mr. Coulson's suggestion that it revisits Section 106 entirely, but I suspect it's got things to worry about right now.
I think so.
Excellent. Well, that brings us to a conclusion. Thanks very much for your comments, James. Hope it's been useful. And as mentioned, the webinar and slides will be up on our website in the next couple of days. In the meantime, good morning, everyone.
Good morning, everyone. Thank you.